Hi, I'm Anna Denton-Jones, and in today's session, I want you to imagine that you're dealing with a disciplinary hearing for somebody who's already got a disciplinary history. So maybe they're on a final written warning, there's been a fresh issue of misconduct, and you're now contemplating dismissal. The employee is then raising the history again and is claiming that perhaps a warning that occurred at an earlier stage in their disciplinary history was unfair. To what extent are you expected to look back and sort of unravel what went on in the past before you can make your decision? But I think there are a number of cases we can look at here, and broadly, the position taken by the courts breaks down to, as often is the case, the detail of the matter. So it depends whether or not the employee is arguing some kind of bad faith or not. So, for example, there was a case against one of the local authorities where a teacher had been given a final written warning as a result of misconduct. She'd appealed against that decision, but for one reason and another, including her trade union rep not being able to make certain meeting dates, that appeal had never actually taken place when a fresh issue of misconduct occurred and the governing board of that school is now looking at dismissing her. Now, she argued that because she felt the original warning, the final written warning, was unreasonable and unfair, that it was not then a fair dismissal for her employers to decide that the fresh act of misconduct justified dismissal. Now, in that case, the Court of Appeal was very reluctant to encourage employers to have to sort of undo history and go back into the past. You can see there's a certain attraction to, once an issue has been dealt with, that's final, and quite often in our outcome letters we write that, don't we, saying, you know, this result is final. And not wanting employers to have to go into lots of rehashing what happened in the past. So in that case, where there wasn't any suggestion of any bad faith as such, there wasn't a requirement for the employer to look behind the circumstances of that final written warning. Contrast that with the most recent case, where somebody worked in a recruitment agency and he was under a final written warning for breaching the employer's own recruitment rules, and he argued that he'd actually been given his final written warning by his manager as a result of his manager sort of scapegoating him, really, for, or in order to cover up the manager's own wrongdoings, and that was obviously unfair. Now, in those circumstances where he's arguing bad faith, then the Court of Appeal found that the tribunal perhaps should have looked a little bit more into the background and what had happened and whether that previous warning was reasonable. In terms of this sort of good faith, bad faith dichotomy that we've got going on here, if you look at the language in the decisions, they're talking about using words like, was it manifestly inappropriate for the employer to have issued that prior warning? Was it done with an improper motive? So obviously that narrows down these circumstances in which the courts are saying it's reasonable to go back into the past and look into what has gone on. Of course, a relevant factor is going to be the extent to which the employee has appealed or not. In this particular case, the employee hadn't appealed. And you would have thought that if you had a burning sense of injustice, that the disciplinary penalty that had been given to you was unfair, then you would have been shouting it from the rooftops. And that's obviously a factor that it's important for the employer to take into account. It's interesting, I often get the case of Airbus and Webb thrown at me as a proposition for the fact that if somebody has had a warning maybe for 12 months or 6 months and that's expired, the proposition that's thrown at me is that then cannot be taken into account. And many of you will have disciplinary procedures which refer to after so many months, this will be taken off your record or something like that. And that's absolutely right. The whole point of putting a time frame on a warning is so that it doesn't last forever. But if you look at the case of Airbus and Webb in any detail, what the judges are saying is, whilst you might not treat the warning as still being live, so in terms of stepping up through that process to get to a dismissal, you may have to go back a level, if you like. When it comes to actually viewing somebody's disciplinary history, then the fact that once upon a time they had a warning for a particular matter is still going to be relevant. And there may be circumstances in which, because there has been this history, that you need to take that into account, and you can still do so based on that case, and that's an important one to remember. If anyone's got any questions as a result of what I've been talking about, please do drop me a line. It's adenton@refreshinglawltd.co.uk. Thank you very much.